All right, today is January 29th, and I wanted to talk about the listing agreement. So we've been spending the last couple weeks talking about the buyer agreement, and I thought it was fitting that we just move right into the listing agreement because these are going to be working together when we put our contracts together, especially when we talk about Form 41C. So if we think about the purpose of the listing agreement itself is meant for all property types. It's to create a listing contract between the firm and the client, but more importantly, to create an exclusive relationship between the client and the firm. It will be the place where you get to determine your compensation, agree on the listing terms, and it will also serve as one more level of proof that we've given the Washington State pamphlet on Washington real estate pamphlet, brokerages in Washington. Sorry, I don't even know what to call it anymore. Okay, so looking at the form itself, I know most of us probably know how to fill in the blanks here, but there's a few things that we should probably be remembering when we do fill in these blanks. So first, we're going to be writing the seller. Now, this would be one person if there was one seller, two if two sellers, and we're going to be putting in the legal seller's name. Also, our office name, that's the office that you specifically work for, property address, city, and zip code. I thought this first paragraph was interesting too, because we have duties when we represent a seller to present all written offers, but in the listing agreement itself, it says that we do not have an obligation to submit any offers if somebody wants to lease or rent or anything other than the agreement of the sale of the property. We have been signing this listing agreement to get a sale, not a listing, or not a, sorry, somebody's microphone is distracting. I don't know whose that is. Okay, so once we've signed this, we have an agreement to sell the property, not to rent or lease. So we are under no obligation to accept any contract other than that. It's really important when we are filling this out, though, to make sure that we have the exact seller name. For instance, the seller's name must match the owner of record. If there's an estate or an LLC, the seller must be listed as legally owned. And if the name is too long for the line, an addendum can be signed and attached with the listing so we can keep the legal name in the purchase and sale agreement. If there are multiple signers, like for a corporation or an LLC, the corporation can be listed as the legal seller's name, and then we can add an additional signing page for all who need to sign. There is a form for this called a 22Z, where we can map out all the signers and attach it so they can all be included. I wanted to pull up some examples of where you find the legal names in the title report. So it'll say that the title is vested in, and it'll have the exact legal way that the title is vested. So the first example is first name, middle, last name, and spouse's first name, middle initial, sorry, last name. Sometimes you'll see if it is an estate, it'll be listed out as the entire legal name of the estate. And the estate's legal name is actually this long. When we do the listing to make it a little bit easier to just kind of keep listed, fit everything in the lines, we may shorten it. As an example for this one, that would be the estate of Rosalie Frances Jackson, or it could be the Jackson estate. Either way, we do need to include this entire legal name when we do the listing agreement. And then again, when we do the purchase and sale agreement. Example number 4 is something that might be owned by an LLC. So if you see this, that would be the legal way that we want to have the listing paperwork written up, or at least signed. And then this one does make note of the legal signers for the LLC. If you're doing a listing for an LLC, make sure you verify who is signing and who has to be on this paperwork. Paragraph 2 is the end date. So this is the final date. This is the amount of time you're going to have to put your listing up, get it live, get it sold. Your entire listing contract expires on this end date. So when you sign this, again, you are signing for the exclusive right to sell. This means no matter who finds the buyer, you are the agent representing the seller. And the exclusivity is the same as an exclusive buyer agreement. So when you fill out the end date, are you looking at average days on market? Are you looking at how you're pricing? Are you giving yourself a realistic time to go ahead and have this sold within that time frame? Are you agreeing to this contract in a time with terms that will give you the chance to sell it? Next is to give the agency pamphlet, and this is your chance to give the brokerage in Washington pamphlet to your seller. When you do this, you're going to be explaining the duties of those who you represent. This agency relationship will be very important for them to understand when explaining the rest of the listing agreement. So it's a great segue to talk about brokerage in Washington, and then it lays out buyer-seller responsibilities and duties. And then you are appointed as their agent. Line 18, there are no other brokers affiliated with this firm, no other brokers that are affiliated with the firm are an agent of that seller. So just as we had that limited dual agency as a firm, this goes into explaining it maybe a little bit better in saying that no other agents in our entire firm are going to be representing that seller. Now, the limited dual agency here in paragraph 4 is going to be the consent or not consent of you specifically being a representative of buyer and of seller. So when talking about this, explain to the client what the limitations are. When you are a dual agent, you are unable to advocate for either party because you have a duty to take no action against the other one. For a client to have full representation, it is really in their best interest to have representation on both sides. There is no office policy surrounding this, but understanding those limitations will help you have that conversation with your client and help them make the choice, with eyes wide open. Any designated broker or managing broker would be acting as a limited dual agent, but neither of us are directly involved in the transaction. So the role of managing broker, designated broker is quite different than an agent itself. The listing date, we now have up to 90 days to prepare our listings. So in those 90 days, this is our chance to get the home market ready. Remember, all listings must be published on the MLS on the list date that you have on here, but we are no longer bound to do so by 5 p.m. The most important part of this paragraph is to explain to the seller that there is no pre-marketing. So if you want to go into more detail, that means there are absolutely no social media posts coming soon, no flyers to be made, no yard signs. You can't send out email blasts. You can't send out text messages. We are not allowed to have home tours and definitely not open houses.
If you don't say the address, can you do a coming soon?
Are you talking about putting it on social media?
Yeah, like do a reel or something like that and just say, hey, we got something coming soon. Can't tell you quite yet where it is, but yada, yada, yada. Nothing detail wise.
Yeah, I've seen a few violations be given for things like that. I think I think you'd have to be very, very careful how you do it. And I don't know necessarily how to tell you to do it in a way that you could get away with it without maybe brainstorming or hearing what you have to say on that. So I'll definitely come back to that though at the end of this. Fair housing. We want to make sure that we are being perfectly, professional with everything we do. All of our interactions have to be fair, and we have to make sure we're not doing anything that violates any protected housing class. So when thinking about this, I pulled up a list of all the no-nos. These are no words. You're not allowed to use them to advertise. You want to be really careful if you're using them to describe anybody who you have an agency relationship with. If you're writing a cover letter to an agent because of, to present an offer, or even, just in normal conversation, make sure that you're just being really careful around some of these words. These are words that are considered potential violations of the fair housing. And if any of these words get flagged in your marketing remarks, then your marketing remarks will be taken down immediately.
Jen, I have a quick question here. Does this only apply to the MLS listing and not our flyers?
The fair housing law applies to everything that we do.
Everything, including
all of our marketing everywhere. Yeah. It also includes the things we say when we do videos and the things we post on our social media.
So it says private community, like gated communities are okay, just not private community. I'm assuming that's what it says.
Yeah.
Okay.
Try to be as much, Joe Friday this, right? Just the facts. We want to stick with just the facts. Talking about compensation. So in your listing agreement, paragraph 7 is where you get to discuss with the seller what you're going to charge. I like to think of paragraph 7 in a couple different phases. So the first step is your compensation as the listing agent. Now, we all have a way that we've probably, hopefully, sold our value before this point. So this won't be an uncomfortable conversation. We should have been able to kind of smoothly move our way into this part. When you're thinking about your compensation, paragraph A is what you get as the listing agent. How much are you charging for the listing? Paragraph A, 7A, subsection II, is what happens in the event that there is no buyer broker, and a buyer just comes to you and wants you to put an offer on a home without being represented. This is the only section of this entire paragraph 7 when you're talking about compensation that gets added together. So the total amount that the listing broker would get is going to be written on line 50. So if you charge a percent, then however much more you would charge to help an unrepresented buyer would be added to that percent and put on line 50. Paragraph B is a little bit more confusing, but if you want to think about it in a way that kind of separates the two on the closing statement, right? The first part of the closing statement, compensation, has listing compensation, and then the second part has buyer compensation. So this paragraph B, 7B, would be the buyer compensation section of that closing statement. So think about it like that. Buyer broker compensation offered is going to be B percent. And then if the listing broker represents both parties, it'll either default to what the buyer broker is being offered, or if there's a different amount you want to put in there, then you can go ahead and place that in here. So the way it works at the end of the day is you get listing compensation because you're the listing broker. And if you happen to be a dual agent, which does take consent from your client on both sides there, you would put that section in BII right here. All right, so what happens if you want to make it less than the two added together? You can actually make a smaller number. You can actually put a smaller number in line 56, because what happens again at the end, at the closing statement, is this subparagraph is put into what the buyer would have received. The first paragraph is put into what the selling agent would have received. And the two together is what the firm gets. And if you are a dual agent, you get what both of those combined would be. All right, there is a tail provision So we have a rule that is a no double compensation rule. And when you put in a tail provision, it basically is covering you for what could be also referred to as the procuring cause. So after the expiration of the listing agreement, if a buyer found the listing because of your marketing efforts, there is an argument that you would be entitled to the compensation that you would have received while it was still live. This is only in effect if they have not signed with another agent, or if they have signed another listing agreement. It would only apply if there was a difference in the amount the other agent charged. You can't charge a seller commission twice. Cancellation without legal cause. So this is an agreement that belongs to the firm. The listings belong to the firm. And a seller can't just up and decide that they want to cancel it without the approval of the firm. It has to be it's a bilateral decision here. One party cannot cancel without the other party. So if a seller decides for some reason without legal cause that they want to go ahead and remove the listing, they want to cancel everything, there is a clause in here that just says they may be liable to damages that have resulted in their cancellation. So are you putting money into a listing and you need to get documentation to be reimbursed? Or what happens if the seller wants to cancel prior to cancellation date, right? So this is what kind of covers those conversations. I would encourage anybody who is facing this potential problem to consider maybe finding another agent within the office who could represent if it's a personality clash. There are definitely things that come into play beyond just somebody wanting to cancel, and hopefully we can head off some of those things. Now, property access. Are you going to be offering people outside of the MLS to show the listings? Are we going to offer compensation to those agents? And, if we're in an area that is closer to another MLS, that might be something you would want to consider doing. If you're not close to another MLS, which I think in the Puget Sound, we're not close to any other one. Do you think you should offer that to those other agents? This really needs to be discussed with your seller. It also, there are forms that need to be filled out if you do offer compensation to brokers outside of the Northwest MLS. And I don't know how the key box entry works. I think that you may need to actually be there for the key box entry, or see if there's a one-time open code that you can get. I know that it is a little bit more complicated than just saying, go ahead and open up the box. When we have a listing agreement, the information is put into the Northwest MLS. This is done for record keeping. It is public information, and the listings may be shared with others outside the state or area. This is just a way for us to publicly kind of track everything. It's also viewed by appraisers and anybody who sells for sale by owner. We can look up that information to do pricing. So this is a pre-agreement to go ahead and let us put that information onto the Northwest MLS. Property condition and insurance. So this is something that, I hope we don't glance over this paragraph. The seller is required to keep the property insured through closing. If the home is vacant, then there may be a homeowner policy that would be beneficial to them to use through the closing. This paragraph basically says that agents are held harmless regardless of the property's condition. It's not an agent's job to ensure the property is well kept, clean, or even safe to walk through. So make sure the seller does have the property insured. This is kind of like a hold harmless. It's not the agent's fault. So please explain that to them, that it would be in their best interest to have the property insured, and they should probably go ahead and make sure it's either walkable, or if not, do things to prevent injury as much as possible, because unfortunately, at the end of the day, us agents are kind of off the hook on that. And then the seller's warranties and representations. First of all, the seller is guaranteeing that they have the right to sell the property. This is why we want to make sure that we pull the title report to make, to just verify that seller. And we are going to go ahead and share pictures. We're going to go ahead and make sure that anything that we're advertising is truthful. The seller must be truthful as much as possible when representing their home or property. Agents are going to be held harmless for misrepresentations by that seller unless we specifically know of material facts that are opposite of what they say. The seller does this by putting through the input sheet. So the seller is representing on the input sheet as well as the Form 17, the things they know about the home. And the seller disclosure statement is required by Washington law. Every seller must fill it out. There are only a few exceptions to this. So if you want to think about it in this way, any living seller has to fill out this disclosure, and all real property has to fill out the disclosure. Manufactured homes on leased land and floating homes are not exempt. They are still part of the Seller Disclosure Act. And this includes property, vacant land, and commercial. For closing, this paragraph says that the seller must provide escrow with the FERPTA form. And if this form is not received, the buyer may be liable for the tax withholdings from the seller. The closing fees at escrow will be split 50-50 between the buyer and the seller. Damages in the breach are typically earnest money. So here we can prepare and predetermine how the earnest money will be refunded to the seller in the event of a breach. Are you going to be splitting 50-50 with the firm and the seller? Would the seller be retaining all of the earnest money? Again, a conversation you need to have with your seller. And then, of course, the attorney fees. Any arbitration would award the attorney fees to the prevailing party. And I think they have upped the legal fees as of this year. Okay, well, that is our 1A in a nutshell.